This employment law video is on constructive dismissal. What is constructive dismissal? There needs to be a fundamental breach of contract by the employer. The breach could be an actual breach or an anticipatory breach, and the employee needs to resign swiftly as a result of the breach. Examples of breaches. It could be a breach of a key express term in the contract, such as, for example, failure to pay the employee their salary, changing the employee's job title from that stated in the contract, or reducing the employee's contractual holiday entitlement without agreement. It could be a breach of an implied term, such as a breach of the implied term of trust and confidence. Examples could include, for instance, bullying by a manager, failing to properly deal with a grievance, discrimination, subjecting the employee to an unjustified performance improvement plan, or excessive workload. It could involve a series of breaches which cumulatively amount to a breach of the implied term of trust and confidence, the last act being the final straw. Each case, though, will depend on its own circumstances. Wrongful dismissal. If an employee establishes that they've been constructively dismissed, they may have a claim for damages for wrongful dismissal. Damages are assessed on the basis of the employee being put in the financial position they would have been in had the contract been performed lawfully. This will normally therefore be the net remuneration for the notice period. It could in some cases be for a longer period if, for example, a contractual disciplinary process had not been followed. Unfair dismissal. Employees who generally have at least 2 years continuous service with their employer may also have a claim for constructive unfair dismissal. In the vast majority of cases where the employee has proven that their employer has fundamentally breached their contract, it will be very difficult for the employer to show that they have acted fairly. One example where it might be possible for an employer to show that they acted fairly is where an employer unilaterally reduces someone's hours due to a downturn in business. The maximum compensatory award for unfair dismissal is the lower of 52 weeks' pay or the fixed current cap. For more information on time limits and bringing claims, do visit my website. That's my video on constructive dismissal. The usual caveat is that this video is for guidance only and should not be relied upon for specific advice. And if you're interested in receiving notifications on other employment law videos, do subscribe to my channel.